Start. In the present case, the said notice does indicate that a copy of the notice was also marked to the petitioner, but on a closer scrutiny, we do not find any such evidence of the said notice having been served on the manufacturer, namely, the petitioner in terms of clause 2.4.1 full stop. In the absence of any such material which could be shown by the learned additional chief standing counsel, we cannot presume that such a notice, which has to be mandatorily served on the petitioner in terms of clause 2.4.1 of 2011 rules, read with section 47, had been served, full stop. This point also deserves notice and will have to be taken care of by the appellate authority, inasmuch as the purpose which appears to be for the sending of said notice and which is mandatory is that the aggrieved manufacturer also has a right to get the sample analyzed, and it is for this that now under the 2006 Act and 2011 rules, the procedure for sampling and analysis requires collection and preservation of the sample to be tested in 4 parts. One part for the aforesaid purpose of an opportunity to the aggrieved manufacturer or affected person under the Act to get the sample analyzed and tested by a laboratory, full stop para. This is also necessary because whether it is suspension or cancellation of license or future prosecution, in both proceedings, the very foundation of the allegations is the chemical report of the food analyst, full stop. The proceedings so initiated has both civil and penal consequences, and therefore the notice envisaged at that stage of sample collection and analysis has to be tendered by the food safety officer, which is a condition precedent for either the designated officer or any other authority to take action on such a foundation, full stop. If this opportunity is denied, then the protection given under the Act would be rendered nugatory, full stop. It is well settled that a procedure prescribed in law has to be followed, and no deviation can save an action in relation to a statute where the consequences are both civil and penal in nature, as in the present case, full stop. The petitioner has made clear statements in the writ petition to the effect that no such opportunity at this stage was given by the food safety officer, and therefore the same deserves to be considered, full stop para. The question of giving improvement notice by the designated officer is the next stage after the aforesaid procedure has been complied with, full stop, even assuming for the sake of submissions that the competent designated officer had sent a notice on 7th of May 2015, then a reply had been sent by the petitioner alleging compliance to the same by withdrawing the entire products of that particular batch number, full stop. This issue also therefore requires to be gone into before the appropriate forum as and when raised in accordance with law, full stop. The appellate authority will therefore have to take into consideration The aforesaid submissions raised on behalf of the petitioner full stop para, the office of the chief engineer, a copy of the said letter was also annexed to the letter of 1999 full stop. In our opinion, comma, the learned single judge was right in dismissing the petition on the ground of delay and laches by holding that the applicant had not done anything for a considerable period after March 1996 when his claim was rejected, even though he was informed about the decision and was very much aware of it full stop. The division bench, in our view, was not justified in setting aside the said order and in directing the authorities to consider the case of the applicant for compassionate appointment and by giving directions to give other benefits full stop. We may also observe that when the division bench of the High Court was considering the case of the applicant holding that he had sought compassion full stop, the bench ought to have considered the large issue as well, and it is that such an appointment is an exception to the general rule full stop. Normally, an employment in government or other public sectors should be open to all eligible candidates who can come forward to apply and compete with each other. It is in consonance with Article 14 of the Constitution full stop. On the basis of competitive merits, an appointment should be made to public office full stop para. The factual position is not in dispute full stop. The charges against the respondent were of a serious nature, implicating acts of embezzlement and misuse of funds of the educational institution full stop. The second aspect of the charge related to an allegation of obtaining appointment on the basis of fabricated documents full stop. The respondent submitted a response to the charge sheet denying the charges. Admittedly, as the learned single judge noted, no date or time was fixed for the inquiry and no witness were examined by the management full stop. Over.